Well, I think it's about time the odds makers got in touch with me because if I had a dollar for every time Blake Lively said she would be at a deposition, swore she'd be at a deposition, explained to us and exclaimed to us she can't wait to be deposed just to turn around and postpone, I'd be a rich woman right now. I wouldn't be sitting here talking to you guys because I would be on an island. I would be on a yacht. But yet, here I am. So, Vegas and the odds makers, call your girl. Let's get into it, shall we?
F around and find out. F around and find out. F around and find out. F around and find out.
Hello, beautiful people, and welcome back to another episode of F Around and Find Out. I'm your host, yours truly, Elsie, and I've been traveling today, and I was so tired. I almost didn't make this video, but I'm like, no, I have to get this out because how many times are we going to do this dance of to be deposed or not to be deposed? That is, in fact, the question. But we're finding ourselves yet again at another deposition that's not happening, that was supposed to happen, I guess, a day ago now. But yet, somehow, very conveniently, Blake Lively has been able to wiggle her way out of this one. And I truly believe Judge Lyman laid the roadmap for this exit. So we're going to begin with one of the first things that hit the docket 2 days ago, I believe now, because I'm filming this in the middle of the night again. But we're going to begin with Jed Wallace's dismissal, which I was happy when I heard about it at first, right? Then immediately after I started reading it, I felt a pause because I realized it was without prejudice. And again, we've come to learn with prejudice means the door is shut, locked, you can never reopen that door. Without prejudice means, well, you could come back whenever you want, again and again and again. So what Judge Lyman did was take Jed Wallace's case out of the court, said it doesn't need to be here, it's not even in the right jurisdiction, but Blake, you can file it again. I just find it a bit curious that this whole time this case has been on his docket, Judge Lyman, you've known it's not in the right jurisdiction. You've known it didn't go through the right processes to get to you. Why did you choose this time to dismiss the case, allowing the Lively parties exactly enough time to wiggle their way out of their positions and use this Jed Wallace dismissal as an excuse? Which is funny if you think about it, because saying you need to get out of the positions because Jed Wallace has been dropped from the case and that changes your strategy doesn't make a lot of sense if you think about it. Why? It's not as though Blake was the one going to be asking the questions. The Wayfair parties were going to be asking you questions. And as much as Jed Wallace is playing a role in this, it's very minuscule. I don't even believe there would have been more than one or two questions from the Wayfair parties to Blake about Jed Wallace. So to say you need to change the positions and move everything around because Jed Wallace has been dismissed from the case, interesting to say the least. It didn't take the Lively parties but a minute to write this letter to the judge right after the dismissal, claiming Plaintiff Blake Lively writes to respectfully advise the court that following today's emergency hearing, counsel for the parties met and conferred and mutually agreed, in light of the court's order dismissing the Wallace parties and Ms. Lively's rights to amend the complaint on or before July 30th, Ms. Lively's deposition will be continued until July 31st. And I know a lot of people had questions. Why would Justin's team agree to this? Why would the Wayfair parties agree to this? They don't have a choice. The judge literally handcuffed them with the dismissal. Once the dismissal happened, regardless of how big Jed Wallace is to the case, regardless of, what part of the case, is important with his aspect of things, as soon as a dismissal of any sort came on the heels of a deposition, the party who is being deposed has the right to, in fact, any of the parties. Justin's party could have been the one saying, hey, we need time. It just so happens that Blake's team jumped on that grenade very, very, very fast. I just find it very curious that Judge Lyman chose this time to go ahead and give this dismissal. Because like I said earlier, you've known this whole time this case has been on your docket, that it's not in the right court. It wasn't filed in the right way. So why are you just now making this decision? But I'll leave that up for your interpretation. One of the other things that hit the docket was one of the creators who was subpoenaed via Google wrote the motion to quash to the court. They, however, did it anonymously. So again, I'm not one of them. It wasn't me because somebody messaged me, are you the anonymous one? It's not me. I'm going to reiterate. If you're going to file any motion with the court, you have to use your full legal name to establish yourself. If for some reason you need to remain anonymous, whether for your own protections, you fear for your life, whatever the case may be, you still have to file a leave. That's when you ask the court for permission to say, hey, Your Honor, I need to file a motion to quash, but and however, I need to do it anonymously. To which the judge will respond with, yes, you can, or no, you can't, and then you move accordingly. The clerk's office has notified the court that it has received a motion from the anonymous owner of a certain YouTube account to quash subpoena issued to Google seeking information regarding that YouTube account. The motion is captioned with the case number of this action. It was submitted anonymously by email to the pro se filing office and does not contain information identifying the movant, the person. Parties in federal court generally must identify themselves by name unless the court has determined that the party's interest in anonymity outweighs the public interest in disclosure and prejudice to the opposing party. Accordingly, the court will not entertain the motion to quash unless it is either de-anonymized or accompanied by a motion regarding leave to proceed anonymously in this court and explaining why the movant's interest in anonymity outweighs the public's interest in disclosure and any prejudice to the opposing party. So very simple there. You're like I said before, you're allowed to file your own motion to quash on your own. You don't need to hire a lawyer and pay the big bucks, but you cannot do it anonymously. The court has to know who you are. They have to be able to identify you by your name or anything of the sort, unless you want to hire a lawyer to ask for leave on your behalf to file it anonymously. But the way this judge has been moving, I don't foresee him granting anybody the right to be anonymous in this case. So if you're one of the creators who received the subpoena, whether you're trying to remain anonymous or not, the motion to quash is not somewhere your anonymity can continue. It probably ends right about, keeping it to yourself that you got it, unless you have a really strong case as to why you should remain anonymous. Then you do have to ask permission from the court before you try to submit a motion to quash as such. And I think maybe one or more content creators have tried, because today the judge sent another ruling saying the same thing. So I'm going to assume more than one content creator tried to submit their motion to quash anonymously, because we have two separate rulings saying you can be anonymous. One of the other things that was on the docket this week was Brett McDowell, the guy who said Ryan used dog pool to bully him because he has a dog that resembles dog pool. I think he's very good friends with Leanne on Twitter, lawyer Leanne. He had written a motion to the court, actually trying to, step in on behalf of the Google subpoenas, which he really didn't have any room to do that. I wasn't expecting that to be granted in any way, shape, or form. And a lot of people had messaged me that I was on the docket because he had to use screenshots from, I think, one of our previous streams with Andy showing that we were talking about that. So he had to use like a picture of me, Andy, I think Ashley and Melanie King, a couple people talking about, but he was trying to caption the words, not our faces. Remember, he sent, I think, a motion to the court to ask for Judge Lyman to recuse himself, which was never going to work in the first place. Then he sent this one about the Google subpoenas. Anyway, so for the reasons that follow, the motion is denied. A motion for reconsideration should be granted only if the movant identifies as an intervening change of controlling law, the availability of new evidence, which there isn't, or the need to correct a clear error or prevent manifest injustice. It's just, there's no point in going through this, because it's just a bunch of case law where the judge says, you, Brett McDowell, have no standing in this case, therefore cannot even ask for anything in this case. And it kind of reads like the judge is kind of annoyed. And then they go on to say the movant has not identified any changes in the law or evidence that would alter the court's decision. Movant argues that the waiver party's disclosure filed on a docket on June 17, 2025, and other newly discovered evidence confirmed that the dog pool character is based on a move-on service dog, and the provenance of the nice pool character remains at issue. The information is not relevant to the court's decision because he tried to use, like I said, the video Andy, me, and Ashley and Melanie King were in, where Leanne was talking about dog pool. He clipped those parts to say we were confirming his dog was dog pool. I want to reiterate, I didn't know anything about Brett or his dog before this case. Leanne brought it to our attention and we were discussing it on the case. So him trying to use that as evidence, I don't think the judge would care because, again, we're just discussing that, if that makes sense to you at all. The information suggesting dog pool is based on a move-on service dog makes no difference because the court's decision did not turn out whether dog pool or nice pool were in fact based on Movan's or his service dog. We also have this motion from the judge today with respect to the Wayfair parties asking for Blake Lively's financial documents to prove the fact that she says Blake Brown Beauty, her hair care products and her other companies suffered throughout the press for this movie. But we also know for a fact that throughout the press for this movie, Blake and those companies were talking about the fact that she was sold out. They could barely even restock. People were crashing their websites, buying everything and, buying everything off the shelves. So the math doesn't math. So the judge ruled today that Blake has to turn in her financial documents at the very least to the Wayfair parties. First Studios LLC, Justin Baldoni, Jamie Heath, everybody over on that side, moved to compel Blake Lively to provide within 7 days a computation of her alleged damages, the theory under which she seeks damages, and the documents supporting the computation pursuant to Rule 26, a verified response to an interrogatory seeking a computation of each category of alleged damage. So the judge went ahead to say Blake doesn't have to show her personal financial documents because they asked for right here the documents relating to her claims for damages, including but not limited to documents sufficient to show her net worth, such as financial statements, assets, and liabilities, the damages requests, and collectively with the foregoing discovery, the damages discovery. So Blake said in her initial disclosure, Miss Lively is entitled to compensatory mental anguish and punitive damages, including treble damages, which is triple, arising from the injuries identified in her amended complaint. I'm still waiting for those injuries, as well as her attorney's fees and costs. At a later date, Miss Lively will provide an estimate of damages in an amount to be determined by an expert in accordance with the scheduling order in this case. Ms. Lively also seeks damages in an amount to be determined by the court under New York anti-SLAPP law. So the judge said the Wayfair party's motion and the Lively response present an issue that was not presented in the prior Lively motion to compel. Whether a request for financial information is relevant to the compensatory business and personal damages should require the production of information such as aggregate net worth, the value of real property, unrelated liabilities, and the value of parties' retirement savings. The cases cited by the parties and that the court cited in its previous order do not contemplate such sweeping production. What is relevant to the case is Lively's business income and expenses, including income from and of her business entities, establishing whether such income and expenses have changed since the events described in her amended complaint. A party's net worth is only relevant here if there is a finding that punitive damages should be rewarded. As plaintiff, Lively is not subject to punitive damages, especially given that information regarding a party's financial documents may give rise to a privacy interest. Lively cannot be compelled to produce documents regarding her personal assets and liabilities with no relationship to any alleged loss in income or opportunities resulting from defendant's actions. Similarly, any documents regarding retirement savings, property values, investments, or other components of a natural person's net worths unrelated to lost profits, income, or business opportunities which have been produced by the Wayfair parties pursuant to the court's order are relevant to Lively's claims for punitive damages. Any information of this type that has been produced should remain strictly confidential pursuant to the court's protective order until and unless it becomes relevant to the punitive damages phase. The motion to compel is granted in part and denied in part. The motion is granted with respect to Lively's obligations under Rule 26A, only to the extent it seeks financial statements and other documents showing the business income of Lively and her businesses for the period January 1st, 2022 to present. Lively shall produce these documents by July 25th, 2025. At least, they don't get everything, but they get what's important for now. Later on, if she's asking for punitive damages and everything, they can, then seek, and file a motion to compel her financial document, her personal ones. But for right now, they get the business ones, which is just good enough to determine how badly she claims Blake Brown was hurt, unless before we know it, she's going to actually say, I'm actually dropping those damages. I no longer want money for saying my businesses were hurt, to which you will have your answer right there. She lied. That was just a quick recap to catch everybody up on what the docket had to offer, which was a lot in the last 24 to 36 hours. Appreciate you guys for being here. Please make sure to like, share, subscribe, and leave a comment. Let me know what you think about the fact that Blake, once again, did not show up to the positions, considering she was so eager and ready to go. We'll give her time to get ready because I'm sure it's going to be difficult, to show up and tell the truth. All right. Have yourselves a great day. I'll see you guys on the next one. See you then. Have a good one. Bye-bye.
around and find